Good morning, Mr. Commissioner, members.
It is what today, 15th, what is the date? 20, 19th. Yes.
Mr. Commissioner, we're ready to proceed. Before I do so, we have invited last week the FSCA and the CIPC to the Commission. The first party made their presentation yesterday. The CIPC provided us with a statement, and with your leave, I just want to read it into the record. It is a statement by Lana van Zyl. She says, I'm an adult female employed at as the Senior Manager, Governance, Surveillance and Enforcement at the Companies and Intellectual Property Commission, CIPC, with the offices located at Block F, Mankey Street, Sunnyside. I have been employed in the CIPC since its establishment in May 2011.
Sorry, Advocate. I think you need to be closer to the mic, so it might be better if you
Thank you.
sit.
I will do so.
Otherwise, we're not hearing clearly.
Let me start again. I'm an adult female employed as the Senior Manager, Governance, Surveillance and Enforcement at the CIPC with the offices in Sunnyside. I've been employed in the CIPC since its establishment in May 2011 and have a total of 41 years' experience in working with the government. I have a direct involvement in the issuing of the compliance notice dated 21 February 2019, signed by Advocate Rory Voller, the Commissioner of the CIPC, addressed to the Board of Directors of the PIC, care of the Acting Company Secretary Wilna Low. It needs to be mentioned that the Companies Act provides in Section 1872 that the CIPC must enforce this Act by, amongst other things, monitoring proper compliance with this Act, subsection 2B. CIPC looked at media articles and what transpired at the PIC inquiry in January 2019. Specifically, Mr. Sihani's evidence caught our attention. Furthermore, the annual turnover figures supplied by IO Technologies Limited to the CIPC and the seeming disproportionality of PIC's investment in IO Technologies Limited led to the CIPC questioning the oversight by the responsible persons within the PIC tasked with the approval of such investments. CIPC consequently requested a meeting with representatives of the PIC, and the requested meeting was held on 20 February 2019. At the meeting, Mr. Chetty and I from the CIPC explained the CIPC's view that there was non-compliance with Section 76 of the Companies Act, that is, standards of directors' conduct, and that the CIPC would be issuing the Board of Directors of PIC with a compliance notice. None of the PIC representatives objected at the time. The PIC representatives were Messrs. Dion Botha, De Villiers Makonku, and Ms. Wilna Low and Candace Abrams. You will recall from previous testimony, Mr. Commissioner, that Candace Adams is the acting risk officer and De Villiers Makonku is the compliance officer. I must also add that nobody of the PIC requested the CIPC to issue a compliance notice. I also need to mention that the CIPC has not informed the Johannesburg Stock Exchange of the issuing of the compliance notice to PIC. The compliance notice is presently subject to pending litigation in the urgent court in Pretoria. It is signed by the person making the statement, Lana van Zyl. Mr. Commissioner, we are ready to start with the next witness. We have quite a busy day ahead of us, and she will be led by my colleague, Advocate Monahela.
Advocate, before we move on to that, perhaps if you could keep track of where this CIPC dispute and court applications goes to and keep the Commission informed about that, so that we know the steps being taken and what's actually going to, what the proceedings result in.
I'm fully informed of that. I will, perhaps after this witness, put it on record where exactly that process is at the moment.
Good morning, Commissioner and members of the Commission. Like my learned leader said, we are ready to proceed, and our first witness is here. The name of the witness is Nomzamo Peje, and her evidence will relate to terms of reference 1.11 and 1.14. The witness is ready to take the oath.
Can you just stand up, please, ma'am? And give us your full names, please. I see it's Nomzamo Colleen Peje.
Yes.
And do you have any objection to taking the prescribed oath?
No, sir. No.
No objection. Do you
No
swear
objection.
that the evidence you're about to give will be the truth, the whole truth, nothing but the truth?
Yes, sir.
Raise your right hand and say, "So help me God."
So help me God.
Thank you very much. You may be seated.
Commissioner, may I just formally request to be seated while leading the witness? I don't want to assume that I'm entitled to sit.
Yes, you may be seated, and that concession is given to you for this whole week.
Thank you, Commissioner. Ms. Pitcher, you have made a statement which you want to present to this commission. Could I just ask you to start reading your statement at paragraph 1?
By all means. I am a major female who was employed by the Public Investment Corporation, the PIC, as communications manager from August 2011 until November 2015. I was in the Stakeholder Relations Division. I was then demoted and transferred to another position in a different division within the PIC. I shall set out the facts relating to my demotion and transfer below. As I shall show, my demotion and transfer was utterly baseless and unlawful. It was nothing but a show of arrogance and power by management. My office is situated at Menlyn Main Central Square, corner of Korobey Avenue and Aramis Avenue, Menlyn Waterkloof, Pretoria. The facts I set out in this statement are within my personal knowledge, unless the contrary is stated or appears from the context, and are, to the best of my belief, both true and correct. Mr. Commissioner, I made the statement voluntarily, and no one instructed me to say anything in the statement that I did not agree with. I make the statement pursuant to a request made by the Commissioner to the people who may have information that can assist the Commission to come forth and place that information before the Commission. I must say, however, that I was initially hesitant to approach the Commission due to the fear of what might happen to me if I testified before this Commission. I remember one colleague whose name I elect not to disclose, asking me whether I would testify. My answer was, immediate response was no. However, I continue to debate the issue with myself. I am aware that things are not as good at the PIC as some, like Mr. Chris Polwane, who is in the executive head, human resources, and has already testified, would have this commission believe. I have been a victim of the unlawful treatment that has been meted out on some of the employees by those in power. I would not wish what happened to me to happen to another person, not even my worst enemy. I have a desire to see things change for the better at the PIC. In order for this to happen, I saw it as a moral duty to testify before this commission, irrespective of what might happen to me for exposing the ill treatment some of us are subjected to in the workplace. Education background. I hold the following qualifications: Diploma in Education from the erstwhile Transvaal College of Education, a Bachelor of Arts in Communications from UNISA, Diploma in Journalism from Damelin College, Bachelor of Arts Honours in Communications from UNISA, Bachelor of Arts Honours Journalism and Media Studies from Wits University, Management Development Program from University of Pretoria, Certificate in Effective Stakeholder Management from University of Pretoria, and Senior Management Program from University of Pretoria. In June this year, I will be completing a postgraduate diploma in Strategic Management and Corporate Governance with UNISA. My career history. I began my career as an English and history teacher and was employed by the Gauteng Department of Education from 1988 until 1995. I then joined the Department of Trade and Industry as Communications Officer. I moved through the ranks and I was appointed Deputy Director Communications. My duties included developing communication strategies and plans for events designed to promote the DTI, arranging television interviews, writing opinion pieces to the media on behalf of the Deputy Minister, leading and organizing communications planning for high-profile events and exhibitions, and writing reports to Cabinet on fact-finding missions. I was employed by the DTI from 1996 until 1999. I was then employed by National Treasury as Director Communications from 1999 to 2002. As Director, I managed the Communications Division of the Treasury. My activities included internal and external communications. Internal communications in turn involved developing and implementing the internal communication strategy, managing the corporate communications unit, controlling the corporate image and identifying an identity of the National Treasury, controlling the flow and nature of information, advising senior management on speaking to the media, project managing the annual report writing from information gathering to printing, designing and editing promotional documents. External communications involved liaising with the media on core business issues, organizing media briefings, identifying and exploiting opportunities for positive coverage, monitoring media and writing a communications and public relations strategy for various events. From 2002 until 2011, I was the director and owner of a business. I do not deem it necessary to set out the detail of that business because they are irrelevant for the purpose of this statement. I was then employed by the PIC as communications manager in August 2011. Initially, I was employed on a fixed-term contract. I attached a copy of my fixed-term contract marked Annexure A.
If I might just stop you there, that position, was it advertised or not?
It was advertised. I was subsequently employed in the same capacity, but on a permanent basis during or about August 2012. I attach a copy of my employment contract after I was appointed on a permanent basis marked Annexure B. I deem it important to set out the provisions of clauses 2.1 and 11.2 of the latter contract, as they are crucial to whether my demotion and transfer was lawful. Clause 2.1 provides that the employer employs the employee and the employee accepts the appointment and shall render services to the employer in the capacity of communications manager or any other similar capacity required by the employer from time to time. Clause 11.2 provided that the employer may, after consulting with the employee, change or amend the employee's duties and responsibilities from time to time in accordance with the employer's operational requirements. My responsibilities as communications manager were, among others, internal and external communications. These roles broadly entailed media relations, public relations, stakeholder relations, speech writing, newsletter compilation, strategy formulation, annual report compilation, and corporate social investment. Since my appointment to the position, I discharged my duties with diligence and the requisite professionalism. At no stage did I receive a complaint from my employer regarding my performance. To the contrary, I was rewarded for my performance. I received both short-term incentive, which is STI, and long-term incentive, the LTI bonuses. I attach as proof of my satisfactory performance letters dated 25th May 2012, 11 June 2012, 24 January 2014, 28 July 2014, 26 February 2015, 26 August 2015, and 11 December 2015, marked Annexure C to Annexure 7, respectively. I draw the Commission's attention to the letter dated 24 January, which is Annexure C3, which states that I was on grade D2. The restructuring process. During or about December 2014, Dr. Dan Machila, Dr. Dan, was appointed as the Chief Executive Officer of the PIC.
Can you give us a moment, please?
Ms. Peche,
Yes,
just
sir.
a question. If you could just give us the reporting lines to the top during that period. Who were you reporting to? And yeah, the
Okay.
reporting lines.
My line manager, sir, at the time was Mr. Sekhuela, who was a senior manager, stakeholder relations. And he was reporting to Ms. Petro Decker, who at the time was the chief operating officer under corporate services, yes. Thank you. During or about December 2014, Dr. Dan Machila, Dr. Dan, was appointed as the Chief Executive Officer of the PIC. After his appointment, the PIC embarked upon a restructuring process. There was general anxiety regarding how the restructuring would affect us as individual employees. On 9th October 2015, a staff meeting was held about the restructuring. A document entitled PIC Restructuring Update Staff Meeting was produced for the purpose of a presentation. I pause to state that the presentation was done by Mr. Chris Polwani. The document, among others, communicated the following. Consultation with staff over the next 2 weeks, which would have been from the 12th to the 23rd of October 2015. Next one, all staff members will be getting letters confirming their status and positions during the one-on-one consultation session from the 12th to the 23rd of October 2015. Employee skill sets, level of competency will be assessed to identify a suitable position. All the regraded jobs have a range to accommodate different levels of competencies and to ensure that salaries are within ranges. There will be no automatic salary adjustment to a higher grade. If there is a competency gap identified, employees will be placed on a training and development program for 12 months to accelerate skills required. I attach a copy of the document marked Annexure D. As it shall appear below, what was stated in the document was not adhered to, at least insofar as employees like me were concerned. Unlawful demotion and transfer. On the 6th of November 2015, I was called to a meeting. It was attended by Ms. Petro Decker, who became executive head, corporate services after the restructuring and has since resigned, and Mr. Polwani. Before the restructuring process, Ms. Decker was the chief operating officer and head of the corporate services department. The stakeholder relations division fell under the department at the relevant time. Mr. Polwani's opening statement was, and I quote, "You are the worst affected by the restructuring in the entire organization." I did not imagine the extent and debilitating effect of Mr. Polwani's statement until I read a letter dated 3rd November 2015 that was handed to me by Ms. Decker. The letter was signed by Ms. Rubina Solomon, who was the General Manager, Investment Management. The letter stated, among others, that I would now be employed as an environmental, social, and governance, ESG for short, analyst, and would be based in the investment management, ESG listed division. I attach a copy of the letter marked Annexure E. Unlike the communications manager position, the ESG analyst position is an entry level and a junior position. The effect of the transfer to the ESG analyst position was that I now had to report to people who would have been my juniors and reporting to me in my former position and division. Therefore, the transfer was nothing but a demotion. I deal in the next paragraph with an issue which also confirms that the transfer was a demotion. Above, I referred to the letter dated 24 January 2014, which confirmed that I was on grade D2. As if the transfer to a junior position was not enough, I later discovered that I had also been moved from grade D2 to grade C5, which was in line with the ESG analyst position. It is important to point out that the letter I was given at the meeting of 6 November 2015 was silent on the issue of the grade. Grade C5 is 2 levels below grade D2. Being on grade D2 meant that I could qualify to participate in the LTI bonus as confirmed by the letter dated 26 February 2015, which is already attached to the statement. Being moved to grade C5 meant that I no longer qualified for the LTI bonus. This was confirmed by Mr. Polwane when he testified before this commission on the 22 January that the LTI bonus is, I quote, limited to a certain pool of employees. That would be grades D right up to the highest level, close quote. The quotation can be found at line 9 to 10 of the transcript of the hearing of 22 January. The demotion also effectively affected my ability to qualify for the STI bonus in that, according to the... Yes?
You are going too fast because I'm just battling to find the letters which you are talking about. Is it G1? I just want the letter of January the 24th, 2014. Where is it in the annexures?
Beg your pardon, Commissioner.
I can see Annexure E is the letter of the 3rd of November, yeah? The position for ESG that I can see.
Yes.
And then Annexure F I can see, yeah, which is the appointment letter. Where's the 24th of Jan 2014?
That should be Annexure C3.
Oh, it's part of those annexures which, okay, all right. And then the letter of the 26th Feb 2015. We just have to make sure we
That should be Annexure C5.
Oh, I see, okay, all right. So it's those like, okay, all right, I get you. I get you now.
May I proceed?
Yeah, please proceed.
The demotion also effectively affected my ability to qualify for the STI bonus in that, according to the PIC remuneration policy, STI is calculated based on the corporate departmental and individual scores for specific grades. This means that for higher grades, the corporate, departmental, and individual scores weighted percentage share in the bonus pool is higher and decreases with lower grade levels. At grade D2, the percentage share of the bonus is therefore higher than at C5. Even though bonuses are discretionary, this demotion just meant that where I did qualify for a bonus, I was further prejudiced due to the unfair process. The demotion was contrary to my understanding of HR processes. I understand that an employee may not be demoted for the sake of being demoted. An employee must have a justifiable basis for demoting an employee. This may, for example, happen where the employee's performance is substandard. However, the employer must first take measures to ensure that an employee's performance is satisfactory, such as making the employee to undergo training. If the employee's performance is still not satisfactory, the employer may demote the employee instead of dismissing them. However, the demotion cannot just happen without the employee being given an opportunity to be heard. In my case, my performance was satisfactory, as is confirmed by the letters referred to above. Therefore, management had entirely no basis to demote me. Before the meeting of 6 November 2015, management had never had any meeting with me regarding my impending demotion and transfer. It will be recalled that in terms of clause 11.2 of the contract relating to my appointment as communications manager, the PIC, which is the employer, might change or amend my duties and responsibilities in accordance with its operational requirements after consulting with me. I can state without fear of contradiction that there was no consultation with me before I was demoted and transferred. At the meeting of 6 November, I was asked whether I had any questions. I stated that I did not have any, although I would have liked to have questioned the decision taken against me. The question I was asked does not by any stretch of imagination amount to consultation. The reason I did not oppose management's decision was that I was confronted with a fait accompli. It is clear from the letter I was given at the meeting that a decision had already been taken before the meeting. As I had said, the letter was dated 3rd November 2015. Therefore, no amount of resistance would have served any purpose. In any event, as many witnesses have already testified before this commission, the culture at the PIC is one of intimidation and victimization. Employees have no option but to comply with management's instructions. I could not have dared to confront management and risk losing my job. Someone might ask why I did not challenge the decision in the courts. The simple answer is that I did not have the resources to do so, while the PIC could have tapped into its own resources. The PIC is reputable for being the largest asset manager in the continent and can afford any cost it might incur in litigation. In any case, any victory in the courts might have been hollow, as I would still have been victimized for daring to challenge management. As my qualifications attest, I am a communications professional. By November 2015, I had at least 20 years' experience in the profession. When I was made an ESG analyst, I had no investment experience at all. The position was completely unsuitable for me. As proof that I was not qualified for the position, I attached a copy of a document setting out the roles of the ESG analyst marked Annexure F. Therefore, given my lack of relevant skills, one would have expected management to have fulfilled its promise that employee skill set, level of competency will be assessed to identify a suitable position, and that if there is a competency gap identified, employees will be placed on a training and development program for 12 months to accelerate skills required. My understanding of the restructuring process, as governed by the Labor Relations Act 66 of 1995, is that an employer must consider suitable alternatives. The employer must give an employee an opportunity to choose from those alternatives. It cannot just impose its decision on the employee. I fail to understand how management identified the ESG analyst position to be a suitable position for me. I was never placed on any training and development program to acquire the requisite skills for the new position. The only training I got was when I was already in the position, and I took the initiative to acquire it. I should not by any means be understood to be saying that I would have been happy with a demotion and transfer if I had been provided with training. I am merely stating that I was not provided with training to show that management's promise was not genuine insofar as I was concerned. I found my transfer to the ESG analyst position bizarre and ironic, to say the least. I say this because the PIC always prides itself as an organization that not only delivers on its clients' mandates, but also exceeds them. To keep this momentum going and to maintain this high standard, it follows that employees must be relevantly skilled and placed in suitable positions within the organization to ensure good performance. My transfer to the ESG analyst position in November 2015 could not in any way properly contribute to the PIC delivering on its promise to its clients. The restructuring process resulted in the Stakeholder Relations Division being renamed the Corporate Affairs Division. All the employees in the former Stakeholder Relations Division but me were transferred to the new Corporate Affairs Division. It is important to note that the roles and duties of my former colleagues in the former division remained the same. Only the names of their positions changed. Insofar as I am aware, none of them was demoted. This begs the question why I was the only employee that was demoted and transferred, especially in the light of the fact that there was a vacant position in the new division to which I could have been transferred. I would like the Commission to require management, in particular Mr. Chris Polwane, to answer this question. I can say at this stage that management will not give any sensible answer to the Commission. Instead, any answer management will give will only demonstrate that the demotion and transfer was nothing but an abuse of power and a demonstration of arrogance by management. I shall return to the issue of the position that was vacant below. At the time of the unlawful transfer, I was not informed what my role and duties in the new position would be, despite the fact that I would no longer be the communications manager. I was not made to sign a contract relating to my new position. It was only in July 2016 that I was made to sign Annexure F, which, as I have said, sets out the role of an ESG analyst. The fact that I was only given the annexure some 8 months after the transfer demonstrates that management did not care about the situation they had put me in. I must say that my signing Annexure F did not mean that I regarded my demotion and transfer as legitimate. I merely signed because I had no option. It was either I signed or I refused and risked losing my job. If I had refused to sign, I would probably have been charged with insubordination, found guilty and dismissed, something which management probably wished to happen. Until today, I have never been provided with reasons why I was demoted, except what I was told by Mr. Polwane, that I was the worst affected by the restructuring. However, what Mr. Polwane said can never be a justification for my demotion. I must say that I am not surprised that I have never been given a reason for the demotion. My performance in the previous position and the reward for that performance demonstrates that none exists. Management demoted me because they felt that they could, not because it was necessary for them to do so. They knew that I was vulnerable and that I would never challenge the injustice I suffered at their hands.
Sorry, can you just elaborate a little bit on the sense of how you were vulnerable and what your vulnerability in relation to what was happening expressed itself?
Yes, ma'am. Right now, it is a known fact that the culture of victimization and intimidation has been rife at the PIC. So, within the context of that description, I could never have dared to challenge that. I felt vulnerable and very, very fearful, you know, in view of what other witnesses and what I have personally experienced based on the culture of intimidation and victimization within the organization. Thank you. In my view, management's intention was to dismiss me. However, as they had no grounds to do so, they devised a plan that would give effect to their decision. And that plan was to make me suffer through the demotion so that I could end up leaving the organization on my own. I was not surprised when I was informed by one of my colleagues from HR that, I quote, "These people no longer want you at the PIC." That colleague advised me to consider leaving the PIC. During the testimony before this commission, Mr. Luyanda Ntuwane testified that he was phoned by a colleague from HR who pretended to sympathize with him. I believe that this was the same person that approached me. I would not be surprised if the person was being used by management to do its dirty work. I am glad that I did not succumb to their plan to force me to resign. I believe that it is the duty of the Human Resource Division to ensure that employees' interests and rights are respected and protected at the workplace. It is said that Mr. Polwane did not ensure that this was done in my case and those of other affected employees. It was his duty to advise management that what they were doing was unlawful and contrary to the laws of our country. I expect him to know that in terms of the law, certain processes must be followed before a decision which will adversely affect an employee may be taken. Instead, Mr. Polwane enabled and assisted management to trample upon my rights. Since my demotion, Mr. Polwane or anyone in management has never bothered to inquire from me how I am coping. The vacant position created by the restructuring. The restructuring resulted in the creation of 2 investor relations positions in the Corporate Affairs Division, one public and the other private and SOE. These positions are both at grade E level. The investor relations public position was filled at the time of the restructuring. The other position, investor relations private and SOE, was not filled during or immediately after the restructuring. It was left vacant. It is important to note that I hold qualifications which are relevant to the position that was left vacant. Therefore, nothing prevented management from appointing me to that position instead of demoting and transferring me to the ESG analyst position.
A question?
Yes.
On paragraph 28, can you please explain these positions briefly, what they mean? Investor relations, public and private, what do they actually mean?
Yeah.
What do they do?
Well, I do not have the job description, at hand. But, investor relations, just from the word, it will be relating, it entails, relating with the outside world. For instance, the investor relations public, I assume that this person would liaise with the clients of the PIC, on what the PIC and how the PIC is investing their monies and all of that. And the investor relations SOEs, I would suppose, and assume that this person will be attached and assigned to dealing with SOEs in the country. But as I say, I speak under correction. A proper job description would be forwarded to in due course. Okay.
Did you engage with management with regard to those positions, seeing that you were now being demoted?
You mean back in 2015, sir?
Yes.
No, I didn't. As I said, I was very fearful. I did not engage. I did not even ask any questions about the demotion. Okay. It is important to note that I hold qualifications. Okay. I think I read this. Okay. Which are relevant to the position that was left vacant. Therefore, nothing prevented management from appointing me to the position instead of demoting and transferring me to the ESG analyst position. Management could argue that the position was on a higher grade than the grade D2 at which I was before my grade was changed to C5. However, that is not an excuse at all. Nothing prevented management from making the position a grade D position to accommodate me. Also, nothing prevented them from appointing me to a grade E position and keeping me on the same salary if they so wished. Their own document relating to restructuring stated that there would be no automatic salary adjustment to a higher grade.
Well, I thought I would wait until you finish the statement.
Yeah.
When you were demoted, did the same happen to your salary? Was it lower than it used to be?
No, sir, my salary was not touched.
It remained the same.
It remained the same.
Can I just ask you this question, which flows from what the question that you were asked? Would management have been entitled to reduce your salary?
Not that, I don't think so. I've heard that by law they were not supposed to touch my salary. Okay. But I must say that even if I had been appointed to a grade E position and my salary been adjusted to that grade, there could not have been no problem. I am aware of at least one employee whose position was rendered redundant and she was appointed to a higher position. Her salary was adjusted to a higher grade. The employee I am referring to is Miss Rubina Solomon. She was occupying the position of General Manager, Investment Management. That position was inexplicably rendered redundant and she was appointed Executive Head, Investment Management. As a result of the promotion, Miss Solomon's salary was increased by a whopping 953,304.21 cents. I attach here 2 copies of a memorandum that was written to Dr. Den to request approval to absorb Ms. Solomon to the Executive Head Investment Management position, and of a letter Dr. Den addressed to Ms. Solomon regarding her appointment to the position marked Annexure G2 and G1 and G2 respectively. These documents were contained in the files which Mr. Polwane placed before this commission when he testified.
If I may intervene, the position of Executive Head Investment Management to which Ms. Solomon was appointed, was it advertised?
No, sir, it wasn't advertised, not that I know of. I haven't seen it. If Ms. Solomon could be promoted and her salary be automatically adjusted to a higher grade, nothing prevented the same being done in my favor. In my view, it is irrelevant that Ms. Solomon's promotion and salary adjustment occurred approximately 2 years after my demotion. The treatment accorded to Ms. Solomon and the one accorded to me shows that employees are not treated equally within the PIC. The evidence that has already been placed before the Commission by some of the witnesses also bears testimony to this unequal treatment. Such differential treatment is reminiscent of a phrase coined by the novelist George Orwell that says, all animals are equal, but some animals are more equal than others. The investor relations position which was left vacant during the restructuring process, was later filled by Mr. Adrian Lekay. According to the documents that were placed before this commission by Mr. Polwane, Mr. Lekay was initially appointed on an 18-month contract. Some of us were not even aware that Mr. Lekay had been appointed to the position until Mr. Polwane testified, as to the best of my recollection, there was no advert to this effect. We merely saw Mr. Lekay on a daily basis at the PIC. He attended staff meetings. We wondered why someone who was not an employee of the PIC attended those meetings. The position was subsequently advertised on a permanent basis, and Mr. Lekay was appointed to it. Surprisingly, Mr. Lekay was appointed directly to grade E3. Mr. Lekay's appointment to grade E3 resulted in his salary on that grade exceeding the salary he was earning on a fixed-term contract by a 333,200. I attach copies of a memorandum addressed to Dr. Dan seeking approval of the appointment of Mr. Lekay on a permanent basis, and of a letter addressed to Dr. Dan to Mr. Lekay regarding his appointment marked Annexure H1 and H2 respectively.
Question? These documents, you got them from the PIC. Where did you get the documents from?
If I may assist, the documents were contained in the files that Mr. Polwane placed before the commission.
Yeah, I can remember that. Yeah, okay.
I was aware that the position was advertised internally. I elected not to apply for it because, first, Mr. Lekay's appointment was, in my view, a foregone conclusion. I believe that he had been appointed on a fixed-term contract for a lengthy period so that he would stand a better chance to be appointed when the position was made permanent. I fail to understand why the position was not advertised on a permanent basis the first time management saw the need for it to be filled. The second reason I did not apply is that management had ignored me when the position was created as a result of the restructuring. If they did not appoint me during that time, I did not see any reason why they would appoint me after the position was advertised. The third reason I did not apply is the remark Ms. Matshepo More allegedly made when I applied for the position of Head Corporate Affairs. I was informed by an employee in the Human Resource Division that Matshepo had gone to that division and asked to be given my CV. I elect not to mention the employee's name for the fear of them being victimized. Matshepo allegedly asked why I thought I could be appointed to that position. Despite the prejudice she had already demonstrated against me, Matshepo was a member of the panel that conducted the interviews. Attempts to have the decision to demote me reversed. In 2017, I mustered the courage to approach Dr. Dan in an effort to persuade him to have the decision to demote and transfer me reversed. I informed him that the demotion was unfair and requested him to do something about the matter. I further informed him that the PIC had breached the contract relating to my appointment as communications manager. I also informed him that I had not been given an explanation for the demotion. I furthermore said that this amounted to a constructive dismissal. Dr. Dan did not give me any reason why I was demoted. Instead, he suggested that we should hold another meeting where Matshepo would be present, since, I quote, she was part of the process. I assumed that the process Dr. Dan was referring to was the one that led to my demotion. A meeting was then held in October 2017, where Dr. Dan and Matshepo were present. I was asked to state the reasons for the meeting. I repeated what I had told Dr. Dan in my previous meeting with him. Ms. More then arrogantly told me that the PIC no longer had an internal communications function. The statement by Ms. More was disingenuous, to say the least. The PIC needs both internal and external communications functions, given its size and importance in the asset management space, especially as the largest asset manager in the continent. The criticism of the PIC by the Standing Committee on Public Accounts, SCOPA for short, also confirms that the PIC needs both internal and external communications functions. When PIC Exco appeared before SCOPA in December 2018, SCOPA publicly criticized the PIC for its failure to adequately communicate. If I remember correctly, SCOPA requested Exco to submit a communication strategy, which should be tabled before SCOPA before the end of its tenure. As further proof that Matshepo's statement was disingenuous, my colleagues who formally reported to me were, as I have said, retained in the corporate affairs division after the restructuring. Those colleagues still perform the same functions they were performing before the restructuring process, including internal communications functions. Matshepo still requires internal communications assistance from these colleagues. The restructuring process only resulted in the renaming of the division, the changing of the titles of the colleagues I have referred to, and the creation of the head corporate affairs investor relations positions. My attempt to convince Dr. Den and Matshepo to reverse the injustice that was perpetrated against me did not bear any fruit. Dr. Den and Matshepo merely demonstrated to me that they were the most powerful people in the organization whose word was final. They told me that they would, not could, do nothing about my situation. This just demonstrated to me that they realized that they had the power to do something, but elected not to exercise it. To make matters worse, they told me that I was free to leave the PIC if I wanted to. This confirmed my suspicion that the only reason for demoting me was so that I could resign. As a result of their demonstration of the power they had over me as their subordinate, I elected not to try to persuade them any further to reverse the decision. I left the meeting disappointed.
Sorry, could you just advise the date of that meeting, the month and the year?
It was in October. We can check the meeting, the date.
Don't need the exact date, but the month and the year?
2017. Yes. Around September, October 2017.
So at this stage, this interaction with you and your demotion and trying to rectify it had been going on from the beginning of 2015 to the mid of 2017, about 2.5 years?
The engagement formally started in September, thereabout 2017. I remember it was after the James Nogu saga. And then
no, the engagement with you towards the end, but at the time when you were first demoted,
yes.
What was that date?
November 6th, 2015.
That's what I'm saying.
That's when I got the letter of demotion.
Your demotion was end of 2015.
Yes.
The restructuring was taking place in 2015.
Yes.
And at this point in time, it was October 2017 when you were still trying to resolve it. So almost 2 years.
Yes.
Thank you.
But I must say that was my initial attempt to talk about it with the then CEO. I'd never done anything about it before.
Tell me, positions of communications manager, which you occupied,
yes,
and the position of general manager, are they the similar level, or is there a difference between them?
No, sir, they are not at the same level. General manager would be quite senior. Further meetings and attempts to reverse my demotion. On August 24, 2018, all female employees at the PIC were given half-day time off to mark Women's Month. I could not leave the office as I had a huge workload on that day. I decided to continue working. Later on the day, Dr. Den came to our floor. He was doing a surprise walkabout on each floor and engaging with staff. He invited me for a chat. We met a week later. At that meeting, Dr. Den wanted to know how I was coping and encouraged me to talk to him. I repeated the request I had made to him and Matepo in 2017. I also informed him that the demotion had negatively affected me in that it had resulted in me losing both the STI and LTI bonuses in 2017. The meetings I had with Dr. Den since August to October 2018 were positive and inspired hope than those we held in 2017. He was more willing to listen to me and do something about my situation. In the meeting of the 24th August 2018, he requested me to give him time so that he could speak to Mr. Polwane regarding the issue. About a week later, Dr. Den informed me that they had decided to take me back to the Corporate Affairs Division. He also told me that he had informed Mr. Botha and Mr. Sekhuela about my return to the renamed division and that they did not object to my return. I then had a meeting with Dr. Den, Mr. Botha, Mr. Sekhuela, and Mr. Polwane, where Dr. Den advised that Mr. Botha and Mr. Sekhuela should sit with me to discuss my new role.
Sorry, can you please explain the sort of reporting line? Who's Sekhuela?
Yes.
Mr. Botha?
Okay. Yeah. Mr. Botha is the current head corporate affairs. And Sekhuela is occupies the investor relations position, public. One of those two positions we're asking about. Yes.
Reporting to?
Pardon?
Who were you reporting to?
The structure.
Who would you report to if, yeah?
Yes, the structure at the moment is flat. Everybody reports to Mr. Dion Botha. Dr. Den advised that Mr. Botha and Mr. Sekhuela should sit with me to discuss my new role. He said that there was no need for him to be present during that discussion. Dr. Den then appointed me to act in the position of Investor Relations Private and SOE. This is the position to which Mr. Lekay was appointed on a permanent basis. I was not aware that Mr. Lekay had been seconded to the Department of Public Enterprises, which is under the leadership of Minister Pravin Gordhan. My appointment was for a period of 6 months from 3rd October 2018 to the 31st of March 2019.
Sorry, can I just ask you something in relation to that?
Yeah.
Given all of the experience of demotion and over the period of that 2 to 3 years that this discussion was going on, when you were appointed to act in the position of investor relations, was there any question at that point in time about your competency? Any reason saying that we were demoted here, now we're appointing you to this position, which, if I can understand it, this was in fact the position you could have been allocated if they had just moved you into that in the first place?
Yes.
Was there any discussion about competency, training, preparations for that role? Anything that would give an indication as to a change of approach that related to why they would feel that you were not going there in the first place, but now are suitable to be acting? Was there any of that discussion at the time?
There was no discussion necessarily about my competencies regarding that role. But I believe that for Dr. Den to deem it fit to promote, to ask me to act in that position, which is a higher position than the one I previously occupied, was a demonstration of his confidence that he had in me, that I'll be able to manage the position. Because Dr. Den was exposed. I used to write Dr. Den's speeches previously when he was the CIO. I used to work with him closely together with Sekhuela in regarding media relations issues. You know, I used to sometimes travel with him when we had projects that we were presenting or maybe sword-turning events where we would be building a hospital and wherever. And I would be responsible for, to write speeches. So he was aware of my competencies. He also, when I was at the communications division, I was responsible to compile a newsletter. In that newsletter, he had a column which was to whom I was responsible for. I used to write those articles and let him just vet them, and then he would okay them. So he knew that I was able to do my work or to execute the responsibilities that come with this position. So actually there was no need in that regard, because he was basically taking me back to my forte.
I mean, I can't question your saying there was no need, but the fact that he agreed with your demotion and transfer, would have assumed that if he wanted now to put you into the position he could have put you in 2 or 3 years prior,
yes,
there would have been some reason given. And did you not ask him, why do you think I'm fit now and I wasn't fit when it was the position available to me in the beginning? Did you have no discussion about that at all?
I didn't have any discussion. In the context of the meetings that we had and the mood of the meetings that I had with Dr. Den since 2018, the meetings were very cordial. And I saw in him someone who wanted to make amends. And that's how I interpreted his gesture. Okay.
But that does assume that there's no advertising, that this is then at his discretion, rather than processes within the PIC that are followed to make these appointments.
Ma'am, this was just an acting position. It's not a permanent position. It's just an acting position for 6 months.
So you would have expected after the 6 months to go back to where you were at your demoted level?
Well,
you may have hoped differently, but that would, if you took the view that it was an acting position,
yes,
the assumption would be you would go back to where you were after the acting.
Yes. As I set out in my statement, I did ask him that question. If you may allow me to read my statement. Okay. My appointment was for a period of 6 months, from October the 3rd, 2018 to 31st March 2019. Dr. Den informed me that I would be paid an acting allowance in accordance with the remuneration policy. I attach a copy of a letter confirming my appointment to the acting position marked Annexure I. I wish to point out and emphasize that I did not beg to be appointed to act in Mr. Lekei's position, as some might think. As I have said, I was not aware that Mr. Lekei had been seconded to Minister Godin's department. In my feelings, in my meetings with Dr. Den, I inquired from him about what would happen to me when my acting appointment came to an end. I informed him that I was not willing to go back to the ESG analyst position. Dr. Den informed me that there would be more need for communications in the PIC in the near future, and that there could be a restructuring at communications. Mr. Botha once informed me that Dr. Den had instructed him to create a position for me. The instruction was allegedly made at a meeting attended by Dr. Den, Mr. Botha, and Ms. Solomon on the eve of my commencement of duty in the Corporate Affairs Division. And I'm thinking that Mr. Polwane could have been part of the meeting because it was an HR-related matter, but I'm not sure about that. I only am sure about these three. In January 2019, I engaged Mr. Botha on the issue of the position Dr. Majila had alleged instructed him to create for me. Mr. Botha has now changed his tune. He now claims that Dr. Den had only mentioned the issue in an informal and general way, whatever that means. The impression I get, however, is that Mr. Botha is now reneging on Dr. Den's instruction, which he did not object to when it was given to him. I have made several attempts to engage with Matsepo in her capacity as acting CEO, to resolve my predicament. On the 29th of January 2019, I exchanged emails with her in an attempt to secure a meeting with her so that we could discuss the issue. I requested that the meeting be held on an urgent basis. My attempt to secure a meeting did not yield any fruit, as it was postponed and on approximately 3 occasions on the basis that other relevant parties were not available. Excuse me. However, on the 15th of March 2019, I received an email from her PA asking if I would still be coming to the meeting. Unfortunately, I could not attend the meeting as I was on sick leave. My conclusion. As I conclude, Mr. Commissioner, I would like to highlight one of the values of the PIC, that is, we care. It is my sincere submission to this commission that as a black woman, I have been subjected to the worst form of victimization and intimidation at the hands of my seniors. All this was done to manage me out of the organization by making my situation unbearable and untenable. This callous and insensitive action, which bordered on arrogance, flies in the face of this value, we care. I have ironically experienced the cruelty and non-caring nature of the people in power that have also caused great pain to me and my family. Mr. Commissioner, I hope that after this commission, the PIC will be a better place to work for. I thank you.
Sorry, can I just ask one question for clarity?
Yes, ma'am.
Your appointment for 6 months is until the end of the month we're in at the moment, March.
Yes,
so you've roughly got 10 more days of that position. Do you have any idea of what happens to you on the 1st of April?
Ma'am, I do not know, but I have already, I'm taking legal, advice privately. I've already communicated this to my line manager, Mr. Dion Buotha, that I am not willing to go back to the ESG analyst position. I made him aware that I will not allow the organization to do what it did to me back in 2015. And for that matter, I am prepared to actually wage a legal war against the organization, despite the fact that I might run out of resources. But he's quite aware. I've written to him, I've written several emails to him to which he's never responded. Thank you.
But just for clarity, there's been no communication from seniors, doesn't matter at which level, advising you that you're being extended in the position. Do you know if there has been an advertisement for that position and that it has been filled or otherwise, or is there no information about the position you're occupying in an acting capacity, or what you will do after the 1st of April?
There is no information, none whatsoever, ma'am.
If I may ask you, you said you were demoted during the restructuring process. Are you aware of any other employee that suffered the same fate?
I am not aware of. Like what Mr. Polwane said, that I was the worst affected by the restructuring. I'm not aware of any person who was demoted 2 grades down, and on top of that, moved to a very strange division and position without any skills. I'm not aware of such.
Okay. Question, in terms of your demotion, I just wanted to find out, is there some way in which there was some breakdown of relationships? Things just don't happen, and if someone, say, feel that they are targeted, there could have been something that has happened along the way. Is there something that you can tell us around that, maybe?
Mr. Commissioner, through you, how I wish to know those reasons, because in my view, like I said, I was working closely, very closely with Dr. Den, actually with both of them, the former CEO, Mr. Elias Masilela, and Dr. Den Machila, in terms of media relations. And I've already mentioned that actually I was writing most of Dr. Den's speeches Mr. Masilela, you know, had the strength of writing and of communication, so there was no need for us to offer him that service. So in the best of my knowledge, I did not have anything against Dr. Dan in particular. I don't know if he had anything negative or against me in particular. I also don't know of anything. I've never, you know, had any run-ins with Matshepo More previously. But clearly, the way they treated me demonstrated that there must have been something. But though, you know, the environment at the PIC is such that also there's a lot of malice spread about people, you know. There's a lot of gossip, and some people find a way of going to the high offices and spread malice about people. And the unfortunate part is that is the lack of existence of the other side of the story at the PIC. By that I mean that a story has got two sides. Usually, you know, people will spread malice, and those who are recipients of that malice never bother to check the other side of the story. One of the things that I had, you know, from being loosely communicated was that, oh yeah, this happened to you because you were close to the former CEO. I said, how so? What does that mean? Because all of us, including Matshepo, Sekhuela, we worked very closely with him, amongst others. And none of that happened to me. Why me? I still don't know.
So currently, I mean, the way things are, you are in limbo in a sense that the position hasn't been, you know, advertised, the one you are doing at the moment. Has Mr. Botha spoken to you about what's going to happen next?
The position is, as it is at the moment, it's filled by Mr. Adrian Lekay. He's just been seconded for a period of time, I don't know for how long, at the Department of Public Enterprises. So it's an occupied position. He permanently occupies the position. So no, there hasn't been any communication regarding my next move or what would happen to me next by Mr. Botha. All he said to me was that, well, the contract is from March and it ends, it's from October and it ends in March, when I was engaging with him, because I have been engaging with him. I have written emails to him, but you know, no, there's just no information regarding that. Yes, it's true. I like the word that you've used, that I am in limbo indeed.
So meaning chances are you will probably be going back to the position which you don't like.
Well, I am prepared to resist that with all the strength and might that I have. Yes.
Okay.
I asked you a little earlier about the levels of the positions of communications manager and general manager, and you said the general manager position is higher than communications. Am I correct?
Yes, sir.
What would you categorize a general manager as? Management position? Is it senior management position? And would communications manager not be categorized as senior management position?
General manager would be senior management position. Communications manager would be your middle management position. Yes. We, however, do not have a general manager communications. I'm not sure what the commission, in what context the commissioner is asking the question, but we do not have such a position as general manager communications.
Well, I was going to address myself to Mr. Monahela, Advocate Monahela,
Okay.
hereafter,
All right.
because he said your evidence will relate to two terms of reference, 1.11 and 1.14. I'm looking at 1.14, Advocate Monahela. It speaks of executive heads and senior managers rather than other managers.
Mr. Commissioner, you will recall that the witness referred to the appointment of Ms. Rubina Solomon as executive head. The question is, according to her evidence, the position was not advertised. She was just her general manager position was rendered redundant, and she was promoted to the executive head investment management position.
And I suppose you would argue that proper processes weren't followed there, in that instance? Is that the aim?
Yes, proper processes were not followed. She was just, the annexure says, or the memo that was written to the CEO requested approval to absorb Ms. Solomon to the position.
And what would the proper due and proper process have been? Being advertised and so on?
I believe it will be that the position should have been advertised so that everyone could compete for it. Because I believe that Ms. Solomon is not the only employee within the investment management division who could have been given the position. There are probably other employees that could have applied if it had been advertised.
If I may add through you, Commissioner, the reason why we juxtaposed my situation with Ms. Rubina's situation is to show how differently we have been treated. She was just catapulted to the next higher position, whereas I was demoted when there was a vacant position to which they should or they could have just appointed me if they wanted. And they didn't. So it's to show how differently we have been treated within the PIC. Thank you.
And was there a position for her to be catapulted to, or was it created specifically for her?
I wouldn't speak authoritatively on that. What I know is that that position was not advertised. The Human Resource Division runs internal adverts, and we all see them. Like I have said, the position in which I am acting was advertised last year in March. I chose not to apply for the reasons that I've already advanced. I did not see an advert like that for the one that Ms. Rubina Solomon is occupying at the moment. And also, previous witnesses did speak to that who came before this commission.
And your old position of communications manager, does that position exist, or doesn't it exist?
No, sir. If I may use this word colloquially, they killed it. It's no longer in the structure. And it is the only position, might I add, that was removed from the structure. All other positions are still there. They were just renamed differently.
And of course, you say, according to your view, there is a need for that position that you occupied in the PIC. You don't agree with it being redundant, as it were?
You mean the communications manager position? Yes, there is a need. It could, whatever the organization chose to call it. Evidence is the fact that they appointed Mr. Adrian Lekay in a position much higher than the one that I was occupying, which speaks of the need for that kind of a function to be there. Otherwise, if there was no need for that, they wouldn't have created that position through restructuring in the first place. And also, based on what Scope has said when they criticized EXCO last year in December, that the PIC is not communicating adequately. And everybody knows that the PIC is in a deep crisis, and we need to communicate, in a crisis situation like this, to give comfort to the clients, to the public, and any other relevant stakeholder. So you cannot afford to be, killing positions that are key for the organization. Just on the last point on my side is that there is a tendency of relegating communications, to the back benches. But communications is actually a strategic management position, which should be taken seriously by the organization that I work for, the PIC, especially in a situation like this. Because right now, what the public, the clients, and government want to know is how is the PIC going to navigate itself out of the crisis in which it finds itself. And it is important for those individuals to be able, to do that, and to do that convincingly, if they are given the space, the time, and the resources by the organization to do that.
Can you just remind me the position held by Mr. Lekay?
Mr. Lekay...
that you are acting in
yes.
now, is that still to do with communications,
yes,
or
sir.
is it something else?
Yes, sir.
Okay.
Yeah, it does, although maybe there are other additional functions because, like I said, it's a public investor relations, SOEs, and whatever they call it. So he would, over and above the communications functions, he would be liaising closely with state-owned enterprises, I would assume.
And you didn't apply for that position?
I didn't apply, say, for the position because, to me, it was a foregone conclusion that it was his. And besides, I also did not apply out of respect, of self-respect and self-preservation. I felt that I did not want to expose myself and legitimize what I would have considered as a process that had a foregone conclusion. That is why I abstained.
Thank you.
Question from my side is that I just want to follow up on something you mentioned about ex-CEOs, people. You mentioned that there could be some undercurrent that there are people who belonged to the last CEO versus Dr. Dan. Is that thing a big thing at the PIC? Is that still continuing? That there's that undercurrent about that? Am I clear?
You are clear.
Yeah.
What I would say, based on my experience, and by the way, this is my 8th year at the PIC, my observation and my experience is that some people thrive by doing wrong things in the sense of bad-mouthing and spreading malice about other people. And they find themselves, maybe promoted or getting huge bonuses or salary increments and all of that. People talk. I do not have hard evidence on that, but I believe that I'm not the only person who is speaking to this issue. So in my experience and in my observation, yes, there would be people that could be viewed as, maybe favorites, for lack of a better word, or people who would easily access the 7th floor, as it were. And I wasn't one of them.
You're referring to the 7th floor, accessing the 7th floor. Who is on the 7th floor?
It was the former CEO, Dr. Dan Machila, and the current acting CEO, Ms. Matsepo More, and the PAs.
Are they the only people that occupy that floor?
I must say the 7th floor is split into two. They occupy a wing, one wing of the 7th floor, and the other wing, I think, is internal audit. Yes.
Follow-up question. Just in terms, you mentioned that there are people who are like favorites of, the powers that be. How do you become that? How does someone become unfavored, and how do others become like favorites? What are the characteristics that you must display to be favored and all that? Yeah, like if you could, what do these people display?
Well, let me start by saying I mentioned that there are people who would access actually the 7th floor easily than others. Of course, interpretation might vary. We could say they are favorites, Like I said, my experience has been that For some people, it would be easy to spread malice, damaging information about other people, and, well, maybe with intentions for favors from those they are taking this information to. If I remember well, Mr. Victor Siane spoke very well to this issue as well.
And how do people fall out of disfavor? You know, how do they suddenly, you know, hear that they don't want to hear, you know, and all that?
It would be very difficult to actually determine that, but I could imagine that if I spread a rumor about you to person X, you will automatically fall out of favor with that person, especially if that person does not do the rational thing and the reasonable thing to actually hear the side of your stories, which makes two sides of the story.
Get it? So it could be that someone says, Ms. Peche said something about some head of a department and it's just a rumor, and now they take it personal and say, I'm going to deal with that person now. Is that what you're saying?
I wouldn't know the issues in particular raised or spread by other people, but I know that there is a lot of malice spread by about people at the PIC. Very damaging, and malice that actually has affected people's destinies and future. And some of them, I want to believe that they are baseless. And that is what makes me maybe think that I could have fallen within that category of people. However, I do not know what could have been spread, what malice could have been spread about me, except what I told you, that I had people comment loosely in the passages that, oh, okay, that's because you were close to Mr. Elias Masilela. And the only thing I was close to with Mr. Masilela was a professional relationship, just as I was close with Dr. Den. I could walk in their offices anytime there was a need for that to happen. You know, I wouldn't even make an appointment. I would phone their PAs, especially when there were pressing media issues. I would simply run to at the time that we were at the 3rd floor on the old building and just walk in and discuss whatever needed to be discussed and leave the. That was just the nature of the relationship with both gentlemen. And just to add, you know, the nature of a communications manager or a professional communications person is that you work with everybody across the board. You work with people within the organization, and I have done that during my tenure at the PIC. I have worked with different divisions. For instance, when I was responsible for compiling the newsletter, I used to have representatives from different divisions who made input from their different divisions, you know, to the newsletter. And constantly we would, you know, communicate with these people, even their heads. I used to sit in listed, you know, meetings, listed division meetings. They had meetings every morning just to check what's happening in the markets for the day and all of that. And I would sit with them just to track on communications issues that would have that we could pick up from those meetings. You know, I worked with people differently across the board within the organizations, besides or over and above the two heads that I am referring to. So there is no way you can be a communications professional and be confined to a particular corner. Otherwise, that you won't be able to effectively communicate on behalf of the organization. And internal communications is as important as external communications. The employees are the most valuable asset of an organization. And sometimes, actually always, it is important to ensure that you communicate with them. I'll give you an example, say. During this whole saga from 2017 about the James Nogu rumors and all of that, there was no proper communications within the PIC. We would rely on external, you know, information from the media and all of that. The only time that I remember that stuff was communicated to us was, I think, when it was discovered actually that Dr. Den didn't have a relationship with Miss Pretty Law and all of that. If I'm not mistaken, that part was communicated. But the rest of it, we were on our own. We were depending on the independent news media, SABC, e-news, social media, and to me, that is bad. That is where you need to actually reinforce your internal communications, because that destabilizes the organization. And indeed, it did, because we didn't have information. We were not sure what next, what else we had to expect, you know, what else was going to come out and how is it going to be dealt with. So that, in essence, has just painted the importance of internal communications in particular.
Thank you very much, Ms. PIC. Thanks for the time that you took to come and testify here before us.
Yes, sir.
And I must say, still being inside the PIC, and you come forward to testify in the way that you have done, required bravery. And I commend you for coming. Okay.
Thank you, sir.
Thank you.
Thank you.
Yes, Commissioner, may we take an adjournment to the tea break?
Can we come back at 10 to?
Yes, Commissioner.
Right, we'll adjourn until 10 to 12.
Mr. Commissioner, we are ready to proceed with the next witness, but before I do so, I undertook to update the Commission on the status of the legal proceedings at the moment between the PIC, the CIPC, and IO. And the situation at today is the following. The PIC launched an urgent application against the CIPC to set aside the notice served on them by the CIPC. It's opposed by the CIPC, but the CIPC has agreed to an extension of the time limit in that notice from 15 days to 60 days. They do not agree and will not concede that it must be set aside, so it's an opposed matter. At the same time, AO launched urgent application against CIPC and the PIC, and wherein they seek the following relief. They want to set aside the CIPC notice, and they want to interdict the PIC to comply with the notice. So that's a different application. It's also an urgent application. Now, those two applications have been consolidated and will be heard in the North Gauteng High Court tomorrow. I'm further informed by the PIC that they have already instructed their lawyers to institute proceedings against IO for an anti-dissipation order of the funds and to reclaim the total amount invested in IO. That is the situation, and I undertake to update the Commission on Wednesday morning of what happened yesterday, what happened tomorrow in court. I will inform the Commission on Wednesday morning of the outcome of that application.
Thank you.
Yeah, Judge, just a question. When the PIC says they need to reclaim the amounts, like how do they mean? Do you know? Did you know?
They'll have to do so through legal proceedings, Mr. Commissioner. So they will have to bring an application in the High Court, or they'll have to institute action.
Thank you very much, Mr. Lever.
Mr. Commissioner, Mr. Mervyn Miller is ready to take the oath.
Mervyn Miller.
Do you swear then that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Raise your right hand and say, "So help me God."
So help me God.
Thank you. You may be seated.
Thank you, Mr. Commissioner. Just for the record, Mr. Miller, before you start your evidence, is it correct that you have prepared the statement yourself?
Yes.
Did anybody, including any member of my legal team, ask you to change or add anything to your statement?
No.
And did you go through your statement?
Yes, I did.
And you didn't find anything added to it that
No,
you didn't
not at
include?
all.
Thank you.
All right. Now, do you confirm the content as correct?
Yes, I do.
Because I will ask you in some instances not to read from your statement, because the Commission already had evidence on matters touched in your statement. I want you to concentrate in your evidence on the issues raised in your statement, but from the perspective as a member of the Executive Committee of the PIC. You understand that?
Yes.
All right, but first of all, I'd like you to tell the Commission in the first couple of
Sorry,
paragraphs.
Advocate, can I just ask that when the evidence is being given and you refer to the minister, can you please just name which minister? Because given the different ministers in a very short period of time, it would just help if we know which one you're referring to.
I will. Thank you, Mr. Commissioner. Thank you, Mr. Commissioner. If I can start, like stated, my name is Mervyn Miller. I'm a 58-year-old adult male, and until last week, the 14th of March 2019, I was employed by the PIC as an executive head of private equity and structured investment products. I've been an employee of the PIC since January 2008, so just over 11 years. The facts, I've already said that the facts are true, and if I go to number 3, I was first seconded to the PIC from an auditing firm where I was doing my articles to assist the PIC in forming a new department at that time called Monitoring and Workout. I was then permanently employed by the PIC on 10 September 2008 as a Monitoring and Workout officer, the first employee in this newly formed division, at that stage reporting to Ms. Pietru Dekker. I was later promoted to the senior manager of the department, and by the time I left the department in 2013, we had about 10 employees in the department. At that point, I was reporting directly to the Chief Investment Officer at the time, Dr. Machilla. This department is now called the Portfolio Management and Valuations Department within the PIC. In February 2013, I was appointed as an associate principal in the private equity division, reporting to the head of the department at that time. In February 2014, I was promoted to the fund principal of the division, responsible for all direct private equity transactions. On 1 January 2016, I was appointed as acting executive head, private equity, for 12 months, up to 31 December 2016, as my manager at the time took sabbatical leave to further his studies.
Can you just tell who it is, who that was?
My manager at the time was Mr. Koketso Mabe. On 1 January 2017, my manager then resigned from the PIC, and after his notice period on the 1st of February, I was again appointed as the acting executive head of the department.
Sorry, just for clarity, that he took a sabbatical for a year and at the end of the sabbatical resigned?
Yes.
So, okay, and therefore you were acting during that period and you became acting again?
Acting again, yes.
You can perhaps, we had evidence previously, but perhaps you can confirm it. During his sabbatical, he in fact got a bonus.
Well, I've heard of it. I obviously don't work in the department, but that's what's been said, yes.
Okay, thank you.
I then applied for the position executive head private equity when it was advertised, and I was awarded the position and appointed on 15 March 2017, and it served in this position until I resigned last week on the 14th of March. I was a member of the executive committee of the PIC for the last 3 years. I've obtained the following qualifications: a BCom Law in 2002, a BCom to Honours Accounting CTA in 2008, LLB degree in 2010. I'm a qualified chartered accountant.
A question, yeah. So before you sort of proceed, can you just please talk a bit to us about what CIPS is and what private equity is, just the lay of the land there? So
private equity is specific investments in mostly in companies that is not listed. In the PIC, the private equity division have a specific mandate, which is to transform the economy. So we will specifically look at transformational private equity deals, mostly in companies that are unlisted or maybe are planned to be delisted, with a certain return requirement, which is similar to all private equity in the market, of over 20%. Structured investment products is a portfolio where we do transformational transactions on mostly listed companies, but where we require underlying protection for those investments. So we've got a couple of different models in that portfolio, and we can send you maybe a presentation of exactly how that portfolio works, if that will assist the inquiry.
Yeah, definitely, please. And where does this division fall under?
The division falls under the private equity department. So the mandate comes from a specific allocation where the listed department also makes use of that specific portfolio to do hedging, normal type of hedging on their portfolio. And then we access that portfolio from the private side to do transformational transactions on listed companies.
So it's a separate division, so it's not enlisted or unlisted, it's a standalone division?
It sits within the private equity department, so it was sitting in my department when I left the PIC.
Okay, all right, thank you.
It's not a separate department. Okay. Thank you, Mr. Commissioner. So I volunteered to assist the Commission with the statement to deal with matters of remuneration and incentives at the PIC. I felt a lot has been said so far at the Commission, and that for various reasons, which will be clear from our statement, I'm in a unique position to deal with this matter and hopefully provide more clarity on it. I believe that the lack of transparency internally and at the PIC, as well as the retrospective interference by the shareholder in the incentives of the PIC staff, creates a risk for the most important resource of the PIC, its staff, to be diluted over time, and the current highly skilled staff complement to be lost to the market. I start off with the one part that I want to deal with under point 16, which is the retrospective shareholder intervention in incentives. I then start with the payment of short-term incentive bonuses to staff and exco within the PIC. The PIC pays its staff members a short-term incentive bonus in August of every year based on each employee's performance for the year ending 31 March. The payment of STIs to staff, including exco members, is regulated inter alia by the remuneration policy approved and adopted by the PIC. I've attached this remuneration policy under Annex A. Section 12.1.5 of the REM policy regulates how the variable remuneration, i.e. the short and long-term incentive bonus payments, are determined. Section 12.2 of the policy records the eligibility criteria and basis of calculation of the STI. In my 11 years at the PIC for the first 5 or 6 years paid STI incentives without fail on 15 June of each year. For the last 5 or 6 years, this changed to payment only occurring in August of each year. There was a couple of times where it even occurred later than this date. This is mainly because of an additional requirement placed on incentives, where incentives can now only be paid when the PIC board approves the annual financial statements of the PIC. The Minister of Finance, as a representative of the shareholder, annually approves STIs before it is paid out to staff members. It is my understanding that the Minister has always only approved the bonus pool for the specific year, and STIs and LTIs were then allocated from this pool. There's only one pool for all staff and exco, and there was a question asked by Ms. Marcus on that specifically. So there's only one pool, and both the STI and the LTI are then allocated from this pool every year. A certain percentage of the pool will be allocated to the STI for that year, and the balance will be allocated to the LTI allocation, which is an allocation which will only then vest 3 years after allocation, subject to the conditions. Up until 2015-2016 year, I'm not aware that the shareholder has suggested any changes to the due amounts when approval was granted. In 2016-2017 allocation, we were informed that certain caps were introduced to the bonuses of staff and exco members by the Minister. These caps were then...
Sorry to interfere there. Can you just tell the Commission who was the Minister then?
I would assume at that stage it would have been Mr. Nhlanhlanene.
Yes.
And in that allocation we were informed, I've dealt with point number 25, the cap applied on exco members was then 80% of their annual guaranteed packages. These caps were now introduced and applied retrospectively to the incentives of the previous year. And this was not a concept introduced ever before and not covered in the remuneration policy.
Sorry, can I ask you, in relation to that and looking at this issue yourself, on what basis can this be applied retrospectively in terms of labour law without consultation or agreement?
So I've had the benefit of actually going through a hearing, and there's various legal opinions which I have attached in the statement as well, which covers the Minister's right of issuing directives, and it's mainly got to do with public interest, where he can make these type of allocations of findings on the bonuses. And it's not just done it with PIC, I understand it's been done with other departments or SOEs as well. I'm not sure if this was properly tested already in law, but we've got legal opinion which I have found through my hearing process that covers his rights to change the bonuses prospectively or retrospectively. I'm not sure if that was really covered, but something that I think is a question.
I mean, I would understand going forward, but I'm not sure about retrospective.
Yes, and that's exactly why I'm covering it here, is the fact that it's being actually applied retrospectively. In the 2017-2018 financial year, the PIC submitted the incentives for the year to the Minister for approval in August 2018, after the board of the PIC already approved it. I'm not privy to these submissions, but I'm aware, though, that in anticipation of the Minister applying caps again to the incentives, a proposal was made to the Minister to apply even more stringent caps to the incentives, and a proposal was made specifically for ExCo bonuses to be capped at 50%.
Sorry, who made that proposal?
So that proposal was made through our HR department, I'm assuming through our HRRC committee and our board, but it wasn't discussed at ExCo level, so I'm not aware. It's from PIC, yes. So the Minister then, by September 2018, had not yet approved the incentives for the year. Staff were getting very impatient at that stage, and at a staff meeting in September 2018, where staff was addressed by the PIC Chairman and Deputy Minister of Finance, that's Mr. Gungubele, staff made it known to the Chairman that they are extremely unhappy with the ongoing delay regarding the payment of the STIs.
And just for the record, the Minister then at the time was Mr. Mboweni.
The Minister at that specific time, I think, was still Mr. Nene. It was at that time when it's going to change. I'm not sure exactly what the date was. It was then agreed that all staff members of the PIC, except ExCo members, be paid the STI bonus payments, and they were then paid on the 30th of September 2018. Their payment was in accordance with the remuneration policy and in line with the PIC board recommendation to the Minister. This effectively meant that the payment was done in line with an agreed pool as presented to the shareholder, as there was no further reduction made to this pool for this payment to the staff. The pool that was agreed and now used to pay the staff is also the one that has been agreed between the PIC and the shareholder in the shareholder compact for 2017 and 2018 that was signed on 7 July 2017 between the parties. So it's an agreement between government and the PIC, and I've attached that as Annexure B.
Does that have an annual renewal, or is it in place until it is reviewed?
It's an annual review.
Annual renewal.
Yes. And you would see, if you go through the legal opinions, a lot of the opinion is based on this shareholder compact. What I haven't stated here is if you compare the previous compact, the 2016-17 compact to the 2017-18 compact, it's only in this new compact that there is a clause stating that the Minister should approve bonuses of the PIC, even though it's been a practice over all of the years that I've been at the PIC. At that same time, there was also pressure for the PIC to release its annual financial statements, its annual report. It was a requirement for the PIC ExCo members' incentives to be disclosed in the annual report. So it was then decided to disclose the amounts requested to be approved with a caveat in the report that these still require approval from the Minister. Incentives for ExCo was then disclosed publicly in the annual report at the 50% cap applied as proposed to the Minister. I refer you to Annexure D, where there's an extract from the annual report where these bonuses for ExCo members was disclosed. Then, only on 14 December 2018, the PIC paid STI bonuses to ExCo members. The STI bonus paid to ExCo members on 14 December 2018 was significantly reduced by the shareholder from the STI bonus amounts reported in the annual report for the PIC for 2018. The STI bonus payments originally recommended by the board had already been reduced significantly by introducing the caps, as I've explained above, and now it's further reduced by the shareholder when it is paid. I refer you to Annexure C, where I've attached the letter from the Minister approving these bonuses to be paid and how he's then calculated these STI bonuses that is then paid to the ExCo members.
This is now Mr. Mboweni.
This is now Mr. Mboweni, yes. So the Minister now introduced a new method of calculating the bonuses to ExCo members. It's also a change to the practices applied at the PIC previously for the 10 years that I've been at the organisation before this. This new calculation is now in direct contravention to the shareholder compact signed between the government and the PIC on 7 July, as I've attached. If you specifically look at clause 9.2 of the agreement, it states that STIs and LTIs shall be paid to members of EXCO in line with the remuneration policies of the PIC, and that the bonus pool shall not exceed 50% of total personnel cost. The calculations ostensibly used by the shareholder to reduce the STI are at odds with the principles contained in the remuneration policy and at odds with the distribution of a pool already approved and used for the payment of the rest of the staff. So government is, in my view, therefore in contravention of this contract. The PIC has not engaged the shareholder on the above breach that I'm aware of and the unfair discrepancies in the calculation and payment of the STI bonus for 2018 as required by the agreement in clause 18, and it seems that it was accepted as a fait accompli. In some cases, the reduced amount paid to EXCO members translated in employees reporting directly to EXCO members and having a lower performance score than the executive, being paid more than the executive. And I think I have about 3 people in my own department where this is the case. The downward adjustment was applied only to EXCO members and not all employees equally or fairly, and again it was applied retrospectively as opposed to giving principles for incentives in future. Even if the Minister's powers are accepted, his calculation in Annexure C was without consultation and resulted in an incorrect formula being used as it double applies performance of the company to the incentive amount. To explain, in paragraph 2, it refers to an assumption that the company's performance was not applied when calculating incentives, but these are already taken in consideration when each individual's score is calculated. So if I can explain it maybe in a little bit more detail, the company gets a performance scorecard that they need to achieve, which is contained in this shareholder compact, and those are then used to compile EXCO members' performance scorecards. So if you got a certain score based on the company's score achieved, by double counting on both sides, you're actually being double applying the performance to the bonus. And that is then what occurred. These bonus payments were also now made some 2.5 months later than other staff and 4 months after being due, with no due compensation for interest or interest added. In fact, the letter from the shareholder was not tabled or referred to the EXCO members either in committee or otherwise. I deal with this lack of transparency later in my statement. This meant that the employees affected by the shareholder's intervention have been kept in the dark as to the basis on which STIs were calculated and reduced, and for what reason the LTI has been deferred. I deal with the LTI in my next section. It would therefore seem as if the shareholder's payment directive is unreasonable, in breach of contract, and that irrelevant factors were considered in determining the STI payments due and payable to EXCO members. There exists no valid or fair reason why EXCO members should not at a minimum be paid on the same basis and calculation used to pay lower levels of management to ensure fairness and prevent high-performing EXCO members from being paid less than low-performing senior managers. So my next section will then deal with the LTI payments, the long-term incentives. So the PIC annually awards and it's very important, the word award, awards to its staff members a long-term incentive bonus each year based on each employee's performance for the year ending 31 March. The PIC annually pays to its staff members all vested LTIs on 31 December of each year based on the conditions imposed by the policy for vesting of LTIs. The remuneration policy read with the shareholders' compact provides for the board to submit its recommendation for the allocation of LTI bonuses to EXCO members on an annual basis to the shareholder. The shareholder is required to approve the LTIs before it is awarded. Again, important to refer to the word awarded, because if you also look at the legal opinions that I have attached, the word award is being used when, most of the time, when used in when the minister's powers are described. So award and payment, I'm making a distinction on that. The policy provides that the allocated LTI only becomes payable 3 years after allocation. An employee has to comply with certain vesting requirements, and if these are met, the payment is made on 31 December. The shareholder has at all times prior to 2018, so every year prior to the last year only approved the allocation of LTIs, and no approval has ever been sought for the payment thereof when the payment is due. All staff except members of EXCO were paid LTI benefits on 31 December 2018. The Minister has discussed before and in his letter requested EXCO LTI payments for 31 December 2018 to be deferred. The shareholder this year, for the first time ever, requested to review the LTI payments of only the EXCO members before it is paid, and you can find that in Annex C. This LTI, currently still being reviewed by the shareholder, was approved by the shareholder in 2016. So I think in 2016 this awarding was approved by Minister Gordon at the time. It would have made sense if the new minister now wanted to have insight in the current year's awarding of LTIs for EXCO members. But he is now reviewing the already approved LTIs that's now only due for payment. No reason or explanation for the continued delay in payment has been forthcoming, and this matter remains unresolved still today. The following features of the LTI are important. I'm not going to deal with 60, I think I've dealt with it enough in the statement. On 61, no fair justification exists for EXCO members being deprived of their LTI payments, whereas all the other staff have been paid their vested allocations. At the time when my LTI was awarded to me, I was not even an EXCO member. So my fellow colleagues who was awarded LTIs at that time now got their payments, and I still haven't received the payment. Having resigned, my only option now is to seek legal remedies at a large cost to myself to try and get these paid to me. I've met all requirements for the vesting and payment of the LTI. My achieved score at the PIC has actually always been way above 4 out of 5, and I easily met all the requirements. I then follow the grievance process, which I deal with from point 65. On 18 December 2018, I was advised by the Executive Head Human Resources that my only recourse would be to lodge a formal grievance as per my contract and the policies of the PIC. I lodged a formal grievance on 19 December 2018 in respect of the STI and LTI issues described above. As there was a significant delay by the employer to entertain a grievance hearing, I, on 12 February 2019, based on legal advice sought, furnished the employer with a letter of demand requiring compliance with the terms and conditions of my contract as it relates to STI and LTI. I've attached that letter of demand as Annex E. The grievance proceedings was then scheduled and heard on 19 February 2019, 2 months after lodging my grievance. And the employer now sought to derail the grievance process by raising a point in limine issue insofar the STI and LTI are concerned, effectively arguing that the grievance process does not have jurisdiction over the matter. This now after dragging me along in the process, which they instructed me to follow for 2 months at that point.
Just to make it clear, you were advised by the Executive Head Human Resources to follow this course.
Yes.
And when it came at last before this grievance hearing, they took the point, the employer took the point, that the grievance process does not have jurisdiction.
Yes. The ruling subsequently by the chairperson of the grievance hearing was that the PIC as an employer could not entertain or endeavour to resolve the grievance insofar as the STI is concerned, as the PIC is bound by the shareholders' decision to reduce the STI of EXCO members. I deal with it a bit later, but on the LTI she found that a hearing could be held because, specifically because the word award, you would see in the legal opinions, was mentioned a lot, and the award was already approved, so she felt that the hearing can be heard, and it was scheduled for 15 March 2019. I might repeat that when I get to that point again. A couple of days before the hearing, the Executive Head HR supplied me with 2 legal opinions sought by the PIC in July 2017 regarding the powers of the Minister with regards to the incentive. I was surprised that as an EXCO member this has never been shared with EXCO before, and still not to date, but I deal with this later in my statement. The ruling of the chairperson relied mostly on these opinions, and I've attached them under Annex F. The grievance relating to the LTI issue was scheduled to continue on 15 March 2019, I've just said that. I was subsequently advised by Senior Counsel to lodge a case at the CCMA, and this was formally lodged on the 8th of March. The LTI payment remains unresolved, and if the Minister chooses to reduce the amount due as well, it will again be a retrospective application of his powers. I have, in line with legal advice source, tendered my letter of resignation to the PIC Acting CEO last week, 14 March 2019. The resignation was with immediate effect as a result of the breaches not being rectified by the employer, and I've attached my letter of resignation. The grievance hearing scheduled for 15 March was thus then not continued. So I then deal with the effect of this specifically on myself, but not as a grievant, more to give you an example of how this can influence and the unintended consequences if this continues for people in the employee of the PIC. So my personal case, I planned to leave the employment of the PIC in August 2017, as I intended to move to the United Kingdom to seek different opportunities and obtain other skills, as I had already at that stage spent 9 years at the PIC, and I felt it was time to move on. At that stage, I've already spent about 3 years planning my move, including going through the application process for an ancestral visa for the UK, as well as registering my kids to start school in the UK for September 2017. After consulting the CEO, Dr. Machella, of my intended move in August 2017, he urged me to stay at the PIC a bit longer, as it was a very turbulent time and there was a general view that external forces were trying to penetrate the PIC. As schools start their new term in September each year in the UK, I decided to move the registration of my children at the school in the UK to September 2018 and stay at the PIC until I receive my STI payment in August. In early 2018, I informed the CEO that I intend to resign from the PIC after receiving my STI in August 2018, this is now last year. On 1 August 2018, as per normal process, I received my performance score from the PIC for the year ending March 2018, which will form the basis of my STI payments for that month. My score was 4.23 out of 5, and I expected a decent STI because of this performance. On 8 August 2018, I took leave from the PIC for 3 weeks, and myself and my family, my wife and 2 kids, 5 and 7 years old, left and moved to the UK. It was my intention at that stage to submit my resignation, as discussed with the CEO, as soon as I received my STI payment later in the month. It was also my promise to my family that after serving my notice period, expected to be no later than the end of September 2018, I will permanently join them in the UK. This already was a very difficult discussion, as they're moving to a new country, and it wasn't an easy discussion. So, point number 84, my STI amount reported in the annual financial statements then was just over 1.8 million rand, and it was definitely worth waiting for this amount for myself and taking some discomfort from flying up and down between South Africa and the UK for a short period of time. At no stage during the next 5 months was there any clarity on how long we will be waiting for the shareholder to approve the STI. And it literally became a case of us hoping every week that it would be approved by the following week. I then, for 5 months, remained in this state of flux, expectation and promise. And you can imagine how this started to influence my family life. I had to fly up and down constantly, and in hindsight, the amount paid in the end was not even worth the effort. In September, when the rest of the staff was paid, the annual report was published, the anticipation was that the end is near and we will be paid soon. Ultimately, we were only paid on 14 December, as discussed above, but now our amounts has basically halved. Our LTI payments was then due on 31 December, and I decided to wait for this payment before I resign and join my family, as it was now only 2 weeks before this payment was due. Our executive head, HR, never shared the letter from the Minister with EXCO, but we were told that the Minister also determined that the LTI payments for EXCO must be delayed until he has made a decision about these. The letter from the Minister was only shared with me in my hearing when requested by my lawyer, and has still not been shared with other EXCO members, but I deal with this later in my statement. I then followed the grievance process as described above, as the pressure for me to join my family has now increased significantly, and I could not afford to wait much longer. The cost of travelling between South Africa and the UK has also now become untenable. Clearly, the Minister's reluctance to deal with the matter expediently has had unintended significant consequences in my life personally, and it's my view that other people could find themselves in similar positions in future if this trend continues. I then start with our new section.
Sorry, just again for clarity. So at this point in time, the LTI has not been paid, and that your STI was half what you expected. Was there any steps taken by the PIC in relation to the shareholder to say, to challenge that position and say, this is what has been agreed, this is what has been published, can you give us details of your arguments, protect your staff, the contracts with the staff actually matter? Something from the PIC to the shareholder that there's an engagement about this matter? Were you aware of anything of that nature?
Yes, as it relates to the short-term bonuses, as I said, my understanding is that there's no further engagement on that, and it has been accepted that the Minister's got the rights and that there's no further point in dealing on the matter. As it relates to the LTI, I am aware that the PIC are in constant discussion and constantly trying to get the shareholder to sign it off. Even when I left last week, I heard that they were still engaging. Unfortunately, this is not shared with ExCo members. You have to hear it through the grapevine typically, but I am aware that they are engaging. Even our board is engaging. So it's a big concern for our board specifically as well. And I know that this is something that they want to deal with urgently. The problem does not lie actually with the PIC or its board. They've been very helpful and very supportive, but it's almost out of their hands.
Advocate, can we ask the board to give us information as where this stands?
We will do so, Mr. Commissioner.
So my next section, I deal with the regrading of staff, changes in salaries, and ExCo's involvement in these. It's firstly important to make a clear distinction between annual increases and increases as a result of regrading or restructuring. All PIC staff annually receives an increase in their salaries based on their performance and their remuneration policy. From time to time, the PIC has undergone restructuring or regrading processes where salaries were adjusted ad hoc as a result of these exercises. These would be done to ensure the PIC is paid in line with the market. In August 2017, most PIC staff were issued with letters stating that they were regraded in terms of a regrading process undertaken by the employer, informed by an independent service provider, and most staff, including ExCo, received significant increases of their annual salaries as a result of this. The regrading was done effective 1 April 2017, and all regraded staff received a back payment in August 2017 for their newly determined salaries. ExCo was never involved in this process and never had sight of the calculations of these increases, and was only supplied with a list of broad criteria used as to how general staff was assessed. In fact, some of us was confused when we saw the back payment being made into our accounts, as we haven't even received letters ourselves at this stage.
Just on this question, in relation to ExCo meetings, was this ever raised by yourselves or other members to say on what basis is this happening? You know, as ExCo members, you have certain obligations and rights. Is there a question that this was ever raised by ExCo members to say, we need to know what's going on?
I'll deal with some of it later as well, but it's definitely the case that on various occasions that we have requested that we be involved to understand the process, and I think there's been evidence led in this commission already of some other ExCo members who's not at the PIC anymore who've confirmed they've also raised it, but I mean, confidentiality of the information was always used as an excuse that ExCo members cannot be that directly involved specifically in those type of amounts.
And at that point in time, the CEO was the acting CEO during this period?
Well,
partly
at that,
was the CEO and then partly the acting CEO?
yes. EXCO has never been privy to how their regrading and increases were determined, as the principles used for staff was different to the principles for EXCO members. Staff in general were quite unhappy with this process, as when people started to compare themselves to their peers, they could not understand the discrepancies between each other. Some people received negligible increases and others very significant increases. Some people received this in some cases caused situations where peers had differences of up to 1 million between each other, and most felt concerned on the criteria applied when they compare their experience, performance and qualification to each other. The lack of transparency created a perception, rightly or wrongly, that favoritism was rife in application of these principles. In my department, it created massive gaps between peers, and I was not in a position as the head of the department to explain the reasons for this. It seemed that only a select few were allowed involvement in determination of staff gradings, and this included the HR head and the CFO at the time, now the acting CEO. I raised a concern on how I cannot be involved in analysing my own staff prior to approval of these new grades, but confidentiality, as I stated before, of the information was always used as an excuse.
Can you just explain to the Commission how can that be an excuse to an EXCO member of this institution?
Yes, I'll deal with the terms of reference of EXCO a bit later. So I totally agree that it can't be an excuse. It specifically actually is a responsibility of EXCO to have oversight over these salaries and gradings and incentives. But as I state throughout the statement, we are not involved in any of those. I was also uncomfortable at that stage to sign the letters to my staff, as some of the other EXCO members were as well. And ultimately, the HR head signed the letters on my behalf to my staff. Shortly after the regrading payments of staff in August 2017, we were told that all appointments of new staff members would now be frozen, as the regrading has now resulted in a shortfall in budget that would first need to be sorted out. The freeze was only lifted in March 2018. This specific freezing...
I'm sorry to interrupt you again. I find it very difficult to understand, and luckily you're in the position of a chartered accountant. How can there be a regrading and then a freeze because of the budget implications? Does that make sense?
It doesn't make sense, no.
Okay.
You would expect the budget to be done before the regrading is implemented.
Thank you.
The freezing of appointments has affected 2 of my staff at that stage significantly, as we just finalized the interviewing process for their appointments and already identified them as successful candidates. This is now for promotions in the department. But due to the freeze, could not finalize these appointments. It was only in March 2018 that we managed to finalize these appointments. As a result of this, they missed the LTI allocation for that year. They got a lower increase, and they also got a lower STI than their peers. They are still paid way below their peers in the department. In August 2018, it's now last year August, EXCO salaries were adjusted again. This was again never discussed with EXCO, and the principles applied was never disclosed. All we were told was that this was still part of the previous year's regrading process, and that EXCO's adjustment was done over a 2-year period. So in August 2018, EXCO salaries were adjusted for effective date 1 April 2018, and a back payment was made to each person. General staff heard of this additional adjustment, and there was further unhappiness generally on how EXCO are paying themselves before looking at the rest of the staff.
It might just be a rhetorical question, given that you've indicated there was no communication to you, but if it was a 2-year regrading process to be paid in 2 parts, why would it have to be retroactive from August to April? Surely it would have just come into effect as something that had been previously agreed in April.
Yes, that's a good question. I don't know. I don't have the answer to that. So the head of HR, after this, told staff at various staff meetings that the PIC is in the process of regrading them as well, and that the implementation of it is imminent. On 16 August 2018, a moderation committee, which is a subcommittee of the EXCO, was held to discuss the regrading of the rest of the staff. I was on leave, but asked if I can dial into the meeting to at least discuss my own staff's gradings. This was the first time since serving on EXCO that EXCO was asked to be involved in the detail of staff regrading and adjustment to salaries. It was strange to me that we are now being asked to be involved, as we were not involved the year before, but thought it was a step in the right direction in creating transparency of the process followed. At the meeting on the day, a spreadsheet was sent to EXCO members with the suggested regrading and salary increases for all staff members, excluding EXCO. As I said, EXCO was already paid at this point. I was then dialed in when it came to the discussion on my team. We had a robust discussion on people and even compared them to their peers in different departments. As I recall, there was an adjustment for almost every person suggested in my team. I was quite satisfied with the approach followed in the meeting, as it now sought to rectify the massive discrepancies between peers that existed because of the process followed the previous year. It's important to state that the CFO at the time, Ms. More, did not participate in this meeting. The meeting then took a break and I was never dialed back in on the day. I heard then that the meeting was rescheduled to a later date. On my return to the office by end of August, I realized that the meeting had still not occurred. A meeting was then scheduled again on 21 September 2018, more than a month later. Our state chair, Ms. More, was in the meeting. I think she was in the meeting. At this meeting, we were issued with the principles that will be applied for the rest of the staff and their regrading at the meeting on that day. If you compare the principles used in the previous year to this year, you would see now that there are some changes made to the principles that will now be applied. The most significant change was that staff who received a grading change within the last 3 years would now not be eligible for grading and additional increases. This is a significant change to the principles used on 16 August 2018, as now only one person in my team will be eligible for a change, as opposed to almost all of the members, as I stated previously. This also does not allow for the gaps now that existed to be rectified. A meeting was then only again scheduled for 19 December 2018. So remember that the regrading of the rest of the staff is by this stage still not done and effected. As now only a meeting was then scheduled 19 December. At this meeting, new principles were introduced again, mainly by the acting CEO. These new principles caused to eliminate even the last person in my team that was eligible. The main new principle introduced was that to be eligible, you now have to have had 3 years of scored performance ratings.
Can I just again ask, these new principles introduced, were they discussed with EXCO?
Yes, so at this specific EXCO meeting on 19 December, these were introduced in the meeting.
No, but the point I'm making, before introduction, were they discussed with EXCO?
Not before, no. So these new principles were then captured and sent to EXCO members by HR on 20 December 2018. I've attached all 3 the principles that I've referred to in the statement under Annexure H. And also there's a 4th additional attachment that deals with a comparison that was made by HR between the principles. It was generally accepted that these new principles will be communicated to staff, and EXCO accepted that we will now only have a regrading of less than 50 people in the organization. It was explained to EXCO by the head of HR that it was always the intention for EXCO's regrading to be paid over a 2-year period, and it should not have been an expectation by the rest of the staff to receive another adjustment for that year. My concern came at a staff meeting somewhere in January 2019, where a question was asked by one of the staff members on where the PIC is at on the regrading process for the rest of the staff. The acting CEO and executive head HR then told staff that the finalization of the process is imminent, and then proceeded to state that the principles applied the previous year has not changed from the year before. I was shocked as I knew that this is not true. I was then approached within the next week or two.
Can I interrupt? At the meeting, you realized it's not true. Was it taken up at the meeting?
No. I was then approached within the next week or two after the staff meeting in the corridor by one of the HR representatives and told that they will send me a memo to sign regarding the regrading. I told him that I'm not willing to sign this memo as staff has now been told that there has been no change to the principles applied and that this is not true. And I was expecting that this memo is actually now going to deal with these changes in principles, which later I've realized was the truth. So if they are not willing to be honest to the staff, then I don't want to be part of the process. I was then told that HR still proceeded to seek signatures from other EXCO members on the matter, but to my knowledge, no one was willing to sign. On 7 March 2019, we were then invited to an EXCO meeting, so not a moderating committee, as previously. So all of the other meetings I was referring to was scheduled as a moderating committee. So now we were called to an EXCO meeting on the 7th of March. And there was no documents or agenda supplied prior to the meeting. The executive head HR then walked in and told the members at this meeting that it will be dealing with the memo that the members are not willing to sign. Ms. Maury was not in this meeting. EXCO members made it known to the head of HR that they felt uncomfortable with the process followed to date and that we should revert to the process followed in August 2018, where it seemed the principles hasn't been changed from the previous year. It was agreed that HR will go back to the spreadsheet used at that meeting, updated with the latest information, and will reconvene the meeting then on 8 March as well as 11 March. Such rescheduled meeting has not been called to date, and the matter remains outstanding to my knowledge. And it was outstanding when I resigned on the 14th of March. My suspicion is that they find themselves again where they found themselves in August 2017, where the fair application of the principles will result in a budget concern or shortfall for the PIC, and that HR probably do not have an answer on how they should deal with this conundrum. In the meantime, staff salaries remain a massive bone of contention at the PIC, with suspicions of unfairness and favoritism. So my next section, incentives of staff and EXCO's involvement. As indicated above, the PIC annually awards STIs and LTIs to its staff, dependent on the application of the remuneration policy and its principles. Each staff member contracts annually with their managers through a balanced scorecard on their performance requirement for the year, as already outlined by the Executive Head of Human Resources to this committee. After the year end of 31 March each year, an employee will rate his own performance, and a discussion about his performance will be held with his manager. Adjustments will be made to the scorecard as agreed between the parties. Every year, EXCO members will be invited to a moderation committee, where all staff except EXCO members will be discussed, and scores will be moderated based on criteria applied at this committee meeting. This meeting generally takes place between May and June each year. The CEO and CFO annually have their own moderating committee meeting to discuss all other EXCO members. The final moderated scores of each employee will only be sent to them formally in August of each year. STIs
Sorry, can I just ask you on that? On the final moderated scores, given the engagement, would those scores be known to the head of department and agreed to in terms of each of their staff members?
Yes. STIs and LTIs will then be calculated based on the scores achieved and pool approved by the shareholder and the principles in the remuneration policy. In my first 6 years at the PIC, the calculation of incentives was extremely transparent. It was very easy to, after receiving your own score as well as the corporate score and your manager's score, to calculate your own bonus according to the principles in the remuneration policy. This has all changed in the last 5 years. As I was not an EXCO member at that time, I do not know why it was changed and exactly how the calculation now works. Since then, the process has become much less transparent, and it has become impossible to calculate your own incentive or to verify the correct application of these principles. In fact, since serving on EXCO, I've realized that not even EXCO members are taken into the confidence of the CFO and the HR head to understand how these calculations are done. I have on numerous occasions requested sight of the model used for the incentives at EXCO meetings. The CFO was always visibly upset when I made these requests, and they have refused to date to share these calculations with other EXCO members. The explanation has always been that it gets audited by internal audit, and there is no need for EXCO to see the model used. We have no idea of what the scope of the audit entails. In a meeting in November 2018, I made the request again to share the model, and it was again refused. The CFO made a comment to the head of HR in another language at the time in the meeting. I was later told that she said to him, "We do not ask them to share their models with us." There's a general perception by all staff and EXCO members that these incentives are tampered with by the CFO and the head of HR. In my belief, this perception is created because of the lack of transparency. The perception is probably incorrect, but could easily be avoided if there was more transparency. It would be very easy for each EXCO member to create comfort to their staff or the process followed if they themselves was taken into confidence on the calculations. As stated in this commission before, EXCO members are then expected to sign the incentive letters to staff that reflects these amounts that they have no sight of or influence over. These letters are normally only given to EXCO members the day before payment of the incentives.
I'm sorry to interrupt you again, and perhaps we need an explanation. It seems from your evidence that EXCO members were united in asking these information from the CFO and the executive head HR. And they were united in refusing it. Why didn't the EXCO members, in the majority, it seems to me, to the CFO and the HR head, why didn't you stand up to them?
I wouldn't say that at any of these meetings there was a united front asking for the information. It might have been one or two people, and the rest would have been very silent on the matter, especially when the answers are coming through very quickly and it seems to be aggravated. But I would think over time, most EXCO members, well, they've all definitely felt that there needs to be involvement. Over time, most of them would have expressed their view, but I wouldn't say it was simultaneous with each other.
Did you feel as an EXCO member that you had the ability to voice your concerns, and you were talking about the CFO prior to her appointment as acting? What was the role of the CEO in relation to this? Because, you know, what I'm asking you is, how much did you feel you were able to ask and get a response from the CEO? Because this isn't just a HR person or a CFO.
Yes, I think that I never really had a view that the CEO is really much involved in the incentives and the calculations. I've never had a discussion with him about it because we always knew it was quite centralized within the HR department, and them reporting to the CFO, the involvement really lied there. I'm not aware that the CEO has requested that this information should be shared with us, but people were generally, I wouldn't say scared, but not or reluctant to ask these questions in the meetings.
But in an EXCO meeting, the CEO is present when these things are discussed?
Yes.
So no role in relation to...
No specific role, no. So I deal then with, in point 48, with EXCO decision-making and transparency. The EXCO members are the Chief Executive Officer, the Chief Financial Officer, and the executive heads of various departments. Whereas the Board of Directors is the governing body of the PIC, EXCO assists the CEO in managing the PIC when the board is not in session. And I refer to the terms of reference as Annexure I of EXCO. Clause 4.1.1 of the terms of reference states that EXCO has the authority to manage the PIC business, operations and staff in terms of the PIC Act and in accordance with directives and requirements laid down by the board. EXCO inter alia defined document and implement parameters and strategies for the PIC on human resources. EXCO is further tasked with implementing the policies and procedures of the PIC. The Human Resources and the Remuneration Committee plays an oversight role in line with its terms of reference and delegated authority. The role that EXCO plays in the preparation and calculation of STI and LTI allocations are, as described above, in my view, not in line with the responsibilities imposed by the terms of reference. All submissions made to the HRRC and board with regards to incentives and regradings are not sent to EXCO for approval first, and EXCO has no involvement in these submissions. It has become noticeable that sharing of HR-related information and developments to EXCO tends to be selective and anything but transparent. Typical examples fortifying such perspective include the fact that EXCO was not taken into confidence on strategic information, such as the legal opinions sought on the shareholders' rights and intervention on the STIs, as I've attached, and the calculations made. So the fact or basis of the shareholders' LTI interventions related information requested from HR. So the only reason I know of the above information is because it was supplied as evidence in my grievance hearing in February of this year. This information, although relevant to EXCO members and their incentives, have still not been shared with EXCO members. Also, the letter from the Minister of 4 December explaining how he came to the new calculation of EXCO STIs has never been shared with EXCO members. I refer you to Annexure J for a couple of email exchanges between myself and the head of HR, where it's evident of this lack of transparency in terms of information. So I say, as can be seen from these email exchanges, there was a general reluctance by the head of HR to share all kinds of information to me, even as it related to my grievance hearing. As all this information, in my view, should have in any case been shared with EXCO. But there's even resistance to share this when it is required for a hearing. Still today, it hasn't been shared with other EXCO members. There seems to be a belief that only certain people are privileged to see this information and most other related information. In my view, this lack of transparency is in breach of the terms of reference of EXCO. In conclusion, shareholder intervention in PIC staff incentives are a big risk to the sustainability of the PIC and its biggest resource, its staff. What will make it more tenable is if the intervention is made prospectively, as opposed to the current retrospective applications of its powers. Staff can then fairly and knowingly plan their lives and their appetite to still work for the organization in future. Any intervention by the shareholder should be handled with care, and I recommend this Commission makes a finding that this intervention can be limited and fair. The problem, unfortunately, is not only external. Even internally, the practices at the PIC needs to change and be more transparent. EXCO should at all times be involved in decisions regarding their staff, salaries, incentives, and regrading. There should be a proper review of practices of staff regrading and salaries to ensure fairness across the board. More than 50% of employees have now joined the union, something never seen before at the PIC. I would recommend that the Commission do a climate survey at the PIC, where the issues raised above can be tested. The findings most certainly would be extremely negative as it relates to these issues and the people responsible for these.
Thank you, Mr. Commissioner. This is the evidence of Mr. Miller.
Section J, you mentioned Section J, but I see it's just presentations, it's not letters.
Sorry, Commissioner, I can also see in my own pack that Section J and H is swapped around.
Oh, yeah.
So maybe it's with everyone now. I thought it was only my pack.
Oh,
so
okay.
H is actually supposed to be J, which is the email exchanges, and then J is supposed to be H.
H, okay, okay. So it's a swap.
Yeah.
Yeah, thanks. Thank you.
If there's no further questions, Mr. Commissioner, can Mr. Miller be excused? I have advised him that there is a possibility that the Commission might ask him to return, and is prepared to do so if requested.
Are you not in the UK? Are you traveling up and down?
I've stopped traveling up and down now, but I'm so used to it, I'm happy to come back.
So are you working at the, are you working now in the UK?
No, I don't have a job yet. I'm planning to actually start my own fund and raise funds for doing similar investments on the continent, still from there.
Yes, thank you very much, Mr. Miller. Thanks for your time, and good luck for your intended future venture. Thank you so much.
Thank you, Mr. Commissioner.
Thank you, Mr. Commissioner. Shall we take the lunch adjournment till 2 then?
Till 2 o'clock then we shall adjourn.